Hello, everyone. Welcome. My name is Kambiz Ranawardi, board member for ColumbiaDC and a graduate of School of Engineering and Applied Science. We are very privileged this evening to have Carol Sanger, Barbara Aronstein, Black professor of law at Columbia Law School, to talk about the year that shook America. This is the first anniversary of the overturning of Roe v. Wade, and this would be in conversation with Hillary Schneller, Senior Staff Attorney at Center for Reproductive Rights, and also co-lead counsel for Dobbs v. Jackson Women's Health Organization. I would like to encourage everyone to check our website for their full bio, but please allow me to briefly introduce our speakers. Carol Sanger is a renowned award-winning scholar of reproductive rights and constitutional law. Her work is widely cited, scholarly publication, other media outlets such as New Yorker, NPR, and New York Times. Her most recent book about abortion, terminating pregnancy in the 21st century, addresses the regulation of abortion and maternal conduct, surrogacy, and the law's relation to culture. Since joining the Columbia Law School in '96, she has been recognized with numerous awards, such as the law school's Willisell M. Reese Prize for Excellence in Teaching, as well as Columbia University's Presidential Teaching Award. Our host, Hillary Schneller, is a senior staff attorney at the Center for Reproductive Rights. She was co-lead counsel on the Dobbs case 1 year ago. She also litigated abortion ban cases and challenges to targeted regulations of abortion providers in various states, such as Arkansas, Kansas, and Texas. She worked closely with the Center for Human Rights team to advance work on maternal health in the U.S. And before that, she was an Equal Justice Works Fellow at the National Women's Law Center, where her work focused on addressing gender discrimination in healthcare. She received her JD from Columbia Law School and her BA from Barnard College. So without further ado, Carol, Hillary, sending to you.
Hello, I'm Carol Sanger, and it's hard to zero in on the right word to use to figure out why we've gathered here this evening. We're not celebrating and we're not commemorating. I would say we're marking and collectively mourning the 1-year anniversary of the Supreme Court's demolition of the established right to choose abortion from the constitutional protection it enjoyed for the last 50 years. What my colleague Hillary Schneller and I hope to do in the first 45 minutes, you all are taking on the second 45 minutes, is to consider 4 issues. First, how we got to this miserable moment. Second, what did Dobbs say and what is Dobbs doing now? Third, what transpired in this reproductively important year that moved us out of the Roe era into the wistful post-Roe era, and now it seems fair to say into the more authoritarian Dobbs era? How could so many of us have lived blithely, it seems now, into adulthood, secure in the highest level of legal protection, only to have it felled with a few determined strokes from Justice Alito's poison pen in Dobbs? And the fourth issue will be we'll close up the discussion at our part by continuing the critique of the case begun by Hillary. And I want to focus on the decision's lack of integrity in 2 particular areas. The decision, if we were British, we might call it a dodgy decision. But I think we can call it, from an American perspective, a real integrity deficit. And so I want to address those 2 areas, address the integrity issue in 2 areas: women in the case and democracy. Okay.
So with that, I think it's also always hard to sort of know where to start the story, but why don't you, Carol, start us off by telling us how we got to Dobbs?
Okay, so some of you I am one, may recall January 23rd, 1973, when the New York Times, the top headline was announcing the death of President Lyndon Johnson, but it was followed by a second smaller banner stretching across the whole page that read, High Court rules abortions legal for the first 3 months. And so began the public life of Roe v. Wade, once one of the most known U.S. case name in the world. Prior to 1973, only 4 states had enacted legal abortion statutes: New York, Hawaii, Washington, and Alaska. But the Roe case introduced a different strategy or a different manner of legalizing abortion, which was by having criminal abortion declared unconstitutional in court. Jane Roe, known to some of you as Norma McCorvey, argued that the Texas criminal abortion statute abridged her right of personal privacy. First time that was attempted. And in a 7-2 opinion, the U.S. court agreed with Ms. Roe on the ground that the U.S. Constitution did provide a right to privacy, which had previously been used to permit contraceptive use, which had been also a criminal banned under a criminal statute in the state of Connecticut. But the court said that this right of privacy was broad enough to include a woman's decision to terminate a pregnancy up to the point of viability when the fetus is capable of living outside the woman's womb. 3 points to hang on to here. First, the basis of the decision was the right to privacy, a doctrine set out in the earlier contraception case and drawn from the right was drawn from several constitutional amendments, which, taken individually for some and collectively for others, created a protective zone of individual decision-making with regard to personal and intimate areas of life, such as using contraception, getting married, and particularly to whom one got married, procreation, and family relationships. Now, the Roe decision produced joy for pro-choice supporters and shock and dismay for pro-life advocates who felt who couldn't believe this had happened, and who felt that the highest court had abandoned both them and the fetus in what they considered a bloodthirsty opinion that had no basis in constitutional text. What do you mean, a right to privacy? Show me the word. So the campaign to overturn Roe began the day the case was decided, and led in part by the Right to Life, National Right to Life organization, and other small pro-life groups. Early efforts focused, the first attempt to get rid of this Roe thing were focused on amending the U.S. Constitution with a right to life or fetal personhood amendment. So the amendments, these amendments proposed, none passed, declared that fetuses were legal persons, and this was a very efficient strategy because it turned abortion into murder, the killing of a person. And now the Constitution says if the Constitution were to have said the fetus is a person, that would have taken care of the whole thing. However, Congress never quite got behind these proposed amendments, and so a new tact had to be found. And beginning in the 80s, the thinking was maybe it's not necessary to kill abortion in one fell swoop, but maybe we can approach its demise incrementally by enacting legislation state by state that makes abortion harder and harder to get. Harder emotionally, say by requiring women to look at ultrasounds before they can give consent to an abortion. Harder financially by requiring clinics to have often unnecessary renovations to their facilities, such as turning an abortion clinic into an operating theater with all the requirements that the state has for that. requiring women to see physicians twice before they can consent or have the abortion, a series of stubborn but persistent procedures that women had to go through before they could consent. And these were bundled together under the name of TRAP laws, targeted regulation of abortion providers. And so many were addressed to providers, others to women patients themselves. And the idea behind TRAP laws was twofold. First, as an on-the-ground tactic, it was thought to reduce the number of abortions, or at least make abortion harder to come by and make women pay more for it. I don't only mean financially, but suffer by having to go through elaborate processes before they could have the procedure. But the second aspect was this, that the Right to Life groups hoped and expected that right to choose groups would challenge these regulations in court, and then would go to judges who would then say, "Oh, I don't know. We don't know about that regulatory that operating theater one. Does that deprive women of having the right to an abortion?" But while they were there dwelling on the actual statute, they were also supposed to say, "While we're here, let's take a look at that underlying right to abortion. And maybe that's where the problem lies, not with these adjustments, but with having it in the first place." And so the game plan was that courts would not only decide, say, if a spousal consent requirement was unconstitutional, but the court would look at abortion right itself and overturn that as well. Thus, as Hillary will discuss, the rush to enact an unconstitutional provision, daring the Supreme Court to take down the entire structure of legal abortion, had begun in earnest. And as we'll see, was aided by various judicial deaths and retirements. And this gets us to the Mississippi case and Dobbs. But you see, the larger structure is that somebody was going to get the first case to be taken by the Supreme Court, which was going to be the full-on challenge to Roe. So Hillary, can you move us forward?
I will pick it up from there and talk through a little bit about the lead up to Dobbs, that case specifically, and sort of through the Dobbs case. Both our strategy at the Center for Reproductive Rights, which was lead counsel in defending the right to abortion, and Jackson Women's Health Organization, which had been the only clinic in Mississippi for a few decades already. Also talk about a little bit what it was like at the oral argument and highlight some aspects of the decision. And I sort of start with the timeline because I'm always getting a lot of questions about the oddities in this case, or what seem like things that are strange about how it proceeded, and wonder whether there was some magic to this case being the one that the court took. But I think given experience of litigating abortion cases now for almost 10 years, things that look unusual in our lawsuits and our litigation, or some are not unusual to us, right? They would be unusual in the way normal litigation happens, but norms are not often followed, procedures are not often followed. So the usual things kind of are not what we're used to in our cases. So to take back to March 2018, Mississippi passed a 15-week abortion ban with an immediate effective date. In short order, within the next few years, about a dozen other states passed bans on abortion at various stages of pregnancy, as Carol mentioned, to essentially provoke the United States Supreme Court to take a case to overrule Roe. So throughout the lower courts, Mississippi, in defending its 15-week ban, argued that there was a way to uphold the 15-week ban, but not run afoul of Roe and Casey. And the reason that's not possible is because Roe and Casey said, at a basic level, a woman has the right to decide whether to continue or end a pregnancy before viability, which is around 24 weeks, sort of in a normally progressing pregnancy. Mississippi was saying, well, there's a way to uphold a 15-week ban because it doesn't totally ban all abortion. It just limits the decision to before 15 weeks. But that's not what Roe and Casey said. They said for every individual person, they have the right to decide whether to continue a pregnancy before viability. So the district court easily held the 15-week ban unconstitutional. On appeal, the Fifth Circuit Court of Appeals unanimously ruled in our favor, including a very conservative judge on the panel, Judge James Ho, who had been appointed by President Trump. Mississippi then filed a cert petition asking the Supreme Court to review the case as expected in June of 2020. They continued making that same argument, but in a footnote added a twist saying essentially, if the Supreme Court can't figure out a way to uphold the 15-week ban consistent with Roe and Casey, it should overrule those cases. In September of 2020, Justice Ginsburg passed away, and about a month later, Justice Barrett was confirmed. And then the case was circulated at the court for about a year, and cert was granted. The court agreed to take the case in May of 2021. And that was both surprising and not surprising, right? The composition of the court sort of previewed that they would take, if not this case, some case that was a direct challenge to Roe. Mississippi's case just happened to be, I think, the first one that was there. In July of 2021, Mississippi files its merits brief and really makes its footnote its entire brief, arguing really, really aggressively that the court should and must overrule Roe and Casey. I'll also just note that at the same time, Texas SB 8 started to move through the courts, and that could be a whole other discussion, but very briefly, SB 8 was a 6-week abortion ban that was backed not by a state enforcement scheme, but vigilante enforcement scheme, essentially allowing any person anywhere to sue someone who aided and abetted a person who would access an abortion after 6 weeks of pregnancy in Texas. The Supreme Court let SB 8 take effect on September 1st of 2021, which stopped abortion care in Texas, essentially all abortion care in Texas, about a year before Roe was overruled. So I think that's just an important backstop to what is happening as we were briefing and arguing Dobbs. And to talk just briefly about our strategy, the center lawyers can count to 5, right? The number of votes we would have needed to keep the ban blocked and stand by Roe and Casey. And given the change in the composition of the court, it was really hard to get to 5. We knew it was an uphill battle, but we were arguing still to win, emphasizing not only the importance of stare decisis, sticking to precedent, but also the bottom line, original correctness of Roe, because for a state to take control of a woman's body and demand that she go through pregnancy and childbirth, all the physical risks and life-altering consequences that has, is a fundamental deprivation of her liberty. So regardless of what the Supreme Court has said, that is true, and it was our job to try to explain that to the court. The other kind of question I get asked a lot is why we argued from the outset that there was no half measure here, there was no middle ground, that the court had a very binary choice to uphold the 15-week ban and overrule Roe and Casey or not. And I'll say 2 things. One is there was really no actual alternative, quote unquote, middle ground to propose. Roe and Casey themselves were compromises, right? Viability in a way was a compromise that was workable for a very long time, but it did not allow everyone or guarantee everyone access to abortion. The other point is that there's nothing more principled about a ban on abortion at 15 weeks than viability. 15 is an arbitrary number, and Mississippi never really justified why it was banning abortion at 15 weeks. They just sort of picked a number, and we had states banning abortion at 20 weeks and 6 weeks and literally everything in between. And finally, if the Supreme Court wanted to come up with something that was a middle ground, they could have done that without us offering it up, and the justices would have been more convincing sort of to each other than any argument we probably would have been able to come up with. I'll talk just briefly about the oral argument, given in particular that this was all happening during COVID, and I think that was an overlay that made it just a little more eerie and just different than other oral arguments. Only the arguing attorneys and one sidekick, essentially co-counsel, could come in to the courthouse, and otherwise the press were the only people sort of in the courtroom. Usually there are other lawyers and public access to the court in person. So the Center for Reproductive Rights Litigation Director, Julie Rickelman, who had argued before the Supreme Court once before, 2 years before Dobbs, in a Louisiana abortion case, argued for us. Solicitor General Elizabeth Prelogger argued on behalf of the United States, again, defending Roe and Casey. And Scott Stewart, the Solicitor General from Mississippi, argued for the state, and again, aggressively arguing to overrule Roe. And I had been to a few Supreme Court arguments before. I had slept outside on the Supreme Court sidewalk during Whole Woman's Health in 2016 and June Medical in 2020, which were Texas and Louisiana abortion cases challenging the trap laws that Carol was talking about before. And the courtroom was full. It was a lively atmosphere. This felt very different, and weird is the main word that has come to mind in reflecting on it over this past year. It felt much more performative. I think, Julie and the Solicitor General of the United States did an amazing job, but in a way it was as if they didn't need to be there. The questions the justices were asking were questions we were prepared for, but the tone and overall atmosphere was just very different. It felt much more performative, that the justices were either performing for the public or for each other, not asking advocates the questions they really, were puzzling over and wanted answers to. Just to disrupt the timeline a bit, because today and it's not a silver lining, but a good spotlight, or a good highlight of some of this chaos that has happened over the last few years. Last summer, Julie was nominated to sit on the First Circuit and had her hearing in September of last year. And today, the Senate took a vote to invoke cloture. So I'm not an expert in Senate procedure, but the first vote of 2 votes they will take for her to be confirmed and sit as a federal judge in the First Circuit, which is just really exciting, and the first time anyone who has litigated abortion cases will really sit on a federal court. So it's great to have someone who I worked very closely with and who has just like the utmost grace, integrity, and brilliance to be able to, add that to the federal courts, which we obviously need a lot more of. I'm gonna fast forward to decision day and just the actual decision itself and highlight a couple of points before we get into what's the aftermath. It's like always hard to pick what the pieces to highlight are, because the tone of the opinion, the majority opinion drafted by Justice Alito, is incredibly aggressive and angry. So the majority, written by Justice Alito, holds that the liberty guarantee, the privacy guarantee of the 14th Amendment, does not include a right to abortion. And it comes to that conclusion based on a review of our country's history and tradition, and finds that the right to abortion is not grounded in our history and tradition, the United States history and tradition. But unlike earlier cases, the Dobbs court takes sort of a different approach to that history and tradition test, and says the question is whether the right in this case, the right to abortion, was affirmatively protected in 1868, which is when the 14th Amendment was ratified, and concludes, of course, it was not. And that is really problematic for a number of reasons. It really freezes rights as they were in 1868 with no prospect of progress, which is really inconsistent with the 14th Amendment and the other Reconstruction amendments, which were meant to be forward-looking and really repair the ravages of slavery, specifically with respect to violations of autonomy, violations inherent, right, in enslavement and sexual violence, family separation, and forced pregnancy. And just the opinion engages in none of that. And I will say the dissent does a very good job of engaging in more of what those amendments are supposed to mean for sort of forward-looking protection. I will leave my other highlights maybe for a little later. Carol, if you want to, if we should pick up with the next piece, or I can briefly say a couple other highlights.
Give us one more highlight.
Okay. I will give you the highlight that I find most disturbing of all of the opinions, actually, which is Justice Kavanaugh's concurrence says that overruling Roe and Casey and finding the Constitution doesn't protect the right to abortion returns the court to a position of neutrality with respect to abortion, because the Constitution is not pro-life or pro-choice, which echoes a point he made during the argument. And I think that is one of the most disturbing things in any of the opinions, because the decision is not neutral. I think the dissent, again, does a very good job of pointing out the court is taking a side. It's taking the side of the government, of the state, against the individual in making these very fundamental, intimate decisions about our bodies and our lives. And if this is neutral, I think that previews a very dangerous path forward.
So Hillary has given us this overview of some of the aftermath in Dobbs. And I'd like to look at a perhaps slightly more abstract problem that we can't know how this is going to play out, but we know that there are big clues and winks and suggestion in the decisions. So I called it dodgy. I mean, it is directing readers forward to a world that I think it doesn't really exist, but it's one that's painted. And I think the best place to start is with Alito's attitude or towards women. I would call it an attitude. He would call it just an absolutely factual description of what women want and why this decision isn't so hard on women, and that everyone's just got all head up over nothing, because he'll tell you why. And just as background, remember that what he says is the reason that he has to overrule Roe is because it was always egregiously wrong. The reasoning in the case was just dead wrong. And it was dead wrong for one particular reason, which was that there is no privacy mentioned in the Constitution. And that this has been an argument that came up from right after Roe was decided. What is the court doing? They're inventing this privacy right. For those who were familiar with all the cases based in privacy, with that, it was an exaggeration and a scare tactic, sort of, what the courts run amok. And but then Alito goes on to say, not only is privacy not mentioned, but the word abortion isn't mentioned in the Constitution either. So what was Roe doing? And, this is just nonsense. One can say, of course, the word abortion is missing from our founding document. The Constitution is not an index listing every human activity that a state might address. Many topics or categories go unmentioned. And this has not deterred the court at all from adjudicating where such things or activities televisions, motor cars, political parties, the Air Force fit into our constitutional order, and how rights connected to those things are protected. Like, does search and seizure follow not only into a dwelling but into a car? There were no cars. Yeah, yes. So, but I want to say there's another word that is not in the Constitution, and that is the word woman. It's not even in the 19th Amendment, giving those absent people the right to vote. But what I want to stress is not what's in the Constitution, but what's, I think, women are also missing from the decision in Dobbs. Or rather, what is missing from Dobbs is any description of women that comports with what social scientists and what everyday experience tells us about what women and their familial and reproductive preferences. We can't see the audience. I'm sure there are women out there, and let me just give an idea of a few examples of how Alito sizes women up. And I want to do this in comparison with how Roe took on the same issue. Roe and Casey both gave considered time and reflection and discussion in the decisions about what an unwanted pregnancy meant for a woman if she couldn't have an abortion. And this is what Roe said. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force a woman into a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress for all concerned associated with the unwanted child. And there's the problem of bringing a child into a family already under psychological and who is already unable, psychologically and otherwise, to care for it. This is just part of a longer discussion that Justice Blackmun has about what are we dealing with here? What does it mean to deprive women of this right to decide not to have that unwanted child? And I'll just say, it's always worth keeping in mind that the difference between a wanted pregnancy and an unwanted pregnancy is about this thin. It's a person can a telephone call from an employer saying, "Oh, by the way, I have to give you a pink slip, you're fired," can make all the difference in whether a wanted pregnancy turns into an unwanted one. A call from a doctor saying, "We got back the test results and they're not what we hoped for," is another example. A boyfriend or partner can call up and say, "I'm out of here." So we see that there are many reasons, and all of these have been studied as causes why women choose to have abortions: partner problems, employment problems, hope for their own future, aspirations. So that's where Roe left it, with I think a decent list of considerations that women have when they have an unwanted pregnancy, and in contrast, Justice Alito says, and he is backed in part of this strongly in the oral argument by Justice Coney Barrett, who was trying to understand. Well, I'll go to her argument first, which was, if there's adoption, what's your problem? Why are you talking about forced motherhood when no one has to keep a baby they don't want? Which strikes me as a particularly cold and unimaginative understanding of what it is to have an unwanted pregnancy for 9 months. Some of you may watch Saturday Night Live, and I can't remember which of the actors does Amy Coney Barrett, but her slogan was that she was yelling, "Just do your 9. Just do your 9 months, have the baby, and give it away. Was that so bad?" And that's kind of Alito's view of this whole thing. But he says, it's not just me being optimistic and saying that. He says, I'm going to show you how the law supports pregnant women. And he says, he says, we have laws that consider that, he says, that pregnancy discrimination is now banned by federal law. Anyone here been pregnant and been discriminated against? I don't know. Even with federal law, Pregnancy leave is now guaranteed in many circumstances, usually for 12 weeks, usually and primarily unpaid. And medical care is covered by insurance for some. And then there's this great example of the safe haven laws, which Justice Barrett is particularly fond of, which are laws that say, if you don't want to keep your baby, you can just bring it to a fire station or a hospital emergency room, and they'll take it from you. So don't worry. And these were laws that were passed to try to, after there'd been hardly a spate, but a couple of instances of babies being found in dumpsters by women, girls and women who didn't want to, who were in denial, many say, that about their pregnancies, and then suddenly they deliver a baby and they get rid of it. And so the safe haven was designed to offer them a different chance, a different opportunity to do something. And New Jersey used to have big signs on the buses during the height of safe haven saying, don't abandon your baby. But what they really meant was don't kill your baby. And I thought that those signs by themselves were very interesting, because I thought about, you get on a bus and you see these big placards, don't abandon your baby. And you wonder, are there pregnant women on this bus? I can't see any, or on the train, the New Jersey Transit. But they must be here because the state is telling them not to do a terrible thing. And so there's a public education about what women are like, which I think is very, maybe there'll be some girl who'll benefit from seeing that placard, but it's part of a program to get us used to thinking of women as hostile to babies, hostile to children. Abortion is murder, and safe haven is in a sense part of that same thing. So what Alito says is that there are plenty of people who want to adopt babies. This just isn't such a big problem. And it paints a picture of something like a maternity version of Mr. Rogers' Neighborhood for unwed mothers, where there isn't much to worry about during pregnancy, well, there is, and or after, there's more, and where everyone just wants to be your friend, especially the state and federal government. Not most of the state and federal governments that we're familiar with have that attitude. So that's the kind of view that Alito shares with us, to tell us there's not really a problem here, and these pro-choice people are not hysterical, but look at all the evidence I've given you. Now, this also, the other thing that Alito says, and this ties in with the second area I wanted to raise, which was democracy. He said, women, you have power, you can vote, you can run for office, you can lobby, you can do all sorts of political activity. And so you can participate. When I said in page 1 of this decision, we're going to return abortion to the people and their elected representatives, he says, I meant you ladies, you can do this. Now, maybe, I don't think the numbers of women in politics and lobbying and so on back it up, but we see that also assumes you've got childcare, you've got financing, you're fundraising. I mean, we know that there's a different path for women than men in politics, although we're happy that women are participating and can vote. And this voting thing leads to the last dodgy bit of the case. When Alito says over and over again, we're returning this issue to the people to decide for themselves. How we do that is through voting. But I wish he had looked at a little more information about what's going on with voting these days. What's going on with voting is an awareness of massive gerrymandering, so that your vote isn't quite what you thought it was. You're gerrymandered into a district where your vote will be diluted if you're not the right kind of voter. And also, we have a slew of laws now trying to make voting harder. The pride we once felt in having, today is early voting in New York. I should remember that. about having early voting or extended voting or absentee ballots. All of those are good, but all of those in many states are being pulled back. And there are fewer days to vote. There are shorter hours, just more, you can't go to the wrong precinct, just more stingier attitudes about people voting. So this reliance on that we're all supposed to feel that we'll be okay with if women really want this and they can get out the vote, they'll be okay. Not quite so. Voting is not as welcoming as it would seem, and yeah. So I wanted to say that the case does a lot of social description, as though this is the way the world is. But I think, in fact, it's not. Oh, the one thing I forgot was 3 years ago, the Voting Rights Act was disassembled more than it has been, so that the protections that were around states that had been discriminating in allowing people to vote were cut back. So that's just another example. So the decision is troubling on so many levels, and it just sits there. And I don't know how one can calculate. I'm 74, and so I don't have 50 years left to have another run up on a new row. This is going to be a lot of strategizing and thinking about how to rectify, at least in those states where it can be done, women sustaining abortion as a right. And we know that that when abortion has been on the ballot in referendum, for example, people don't vote for personhood amendments. People don't vote for the smallest period of time to people, some of which are women, the smallest period to have a cutoff for when you can have an abortion. So there is some hope, and states that one wouldn't think are, they're not pro-choice, they're pro-women, I guess I'd say, and they vote to sustain more of a right to abortion.
The states that are restricting voting rights are the same states that are banning abortion. Right now, there are 14 states that have banned abortion, and maybe in the Q&A we can get more into some of what's happened in the aftermath, because it has been a truly devastating public health crisis and legal crisis across the country. But right now, there are 14 states that have banned abortion. Those are also the states that are the most gerrymandered and where it is hardest to actually get to the polls. So from the outset, the premise that voting will get us out of this has that flaw. The other is just, even if all of our rights to vote were at the highest levels, right? These like really fundamental individual rights just shouldn't be up for a popular vote. It shouldn't matter that a majority of people in my state agree I am a person. So I think the fact that abortion is popular and does well when it's on the ballot, right? We saw 6 ballot measures about abortion in 2022, and all of them went in favor of abortion, is great. And I think that is important. It means people care about the issue when asked directly about it. But there is also something disturbing about relying on, right, a majority vote to decide whether we have this right or not.
Yes, and that's just a helpful thing to keep in mind all the time, that voting, getting a referendum passed may be better than it was before it was passed, but it's how we got to Roe in the first place, by the Supreme Court saying this is a fundamental right in line with other rights we have. And so there's just much greater solace in that. I wanted to go back to one other weird thing that Justice Alito said. He said, we figuring out what women want and whether they relied on Roe is really hard to know. He says that form of relying on Roe so that we should keep it, as which is a doctrine, depends on an empirical question that is hard for anyone, in particular for a court, to assess, namely the effect of the abortion right on society, and in particular on the lives of women. Well, that is really silly. A silly sentence, because we have quite a lot of social science evidence on the effect of the abortion right on society, and in particular on the lives of women. And I wanted to just give you two sources. There's a relatively new book out called The Turnaway Study, which very interestingly followed women who were chronologically too late to have an abortion in the state where they lived, and were turned away by the abortion clinics who said, "I'm sorry, but you're 18 weeks pregnant. You can't have an abortion here." And this study followed them and interviewed them. And the book is a lot of narratives by these different kinds of women who turned away. And what the conclusion was that everyone who got an abortion when they wanted one turned out to have an easier life. They were better off than the women who were turned away. Not that the women who were turned away put their children up for adoption or had dreadful lives, but they were poorer, they were sicker, and they were less wealthy, fewer resources. So when Alito says, this is empirical, and gosh, what's a poor judge supposed to do? Well, a judge could read a book. And that would be really helpful. I wanted to suggest one other article to read, which I thought was really, really helpful. And it's about 2 years old, and it's by a writer named Merritt Tierce. And it was first published in, I think, in the New York Times Magazine section, but it's available online. And she also reads it online. Merritt Tierce, Tierce. And the article is called "The Abortion I Didn't Have." And so when we're trying to think of what's the effect of abortion on women, having one or not having one, her article is extremely thoughtful analysis of how she felt for her whole life by raising a child who she didn't want to have, and how she felt it wasn't fair to her son, that she knew there was enthusiastic mothering, and then there was her situation. And as she says throughout the book, I would never have given him away. I didn't have an abortion, but I knew my whole life. I'm trying to find, sorry here. She says, I didn't abort my son, but I aborted my idea of my life. And it's a very thoughtful and slow essay. And so I think people might look at that, including Justice Alito. So I guess this go ahead, Hillary.
Yeah, and just to say, the authors of the Turnaway Study submitted an amicus brief to the Supreme Court. Nobel Prize winning economists submitted a brief to the court to explain all of the things that you just pointed out and more. So it's not that the information was hard to find. The majority of the court just didn't engage with it, which I afraid is even worse. It was right there for them to look at. And there was a brief filed by over 6,000 people who've had abortion during the time, over the last 50 years, right, signing their names from all 50 states and the territories, right, saying this is important to me, to my life. And right, not just abortion, but the ability to have made the decision either way, because I think some of what also gets lost in I think it's important to frame as the right to abortion, but it's also, if you don't have the right to end a pregnancy, do you have the right to decide to continue it? Or is that the state sort of making decisions for all of the people who are continuing pregnancies? It's sort of about the who decides.
Yeah,
that's
right.
Can go disturbing in other directions.
Right. And I guess the one thing we shouldn't leave out is, and I think you touched on it, was what does this mean for contraception? And what does the Dobbs case mean for same-sex marriage? Why those two examples? Because they are also based on the right to privacy or the right to liberty, which they knocked out also in this case. So there are other activities which are grounded in the same legal analysis. And it's, I think, foolhardy to think that they're not going to be, certainly contraception has its head on, I think is the next one to have its head on the chopping block. And there are already states that are taking action in this direction. So Dobbs is not only distasteful in itself, but it has, it portends ill for reproductive issues and anything really based on privacy, which is sometimes called substantive due process. If you'll hear that phrase as well. So should we take some questions?
Great. Thank you both so much. So we already have about 9 questions in the Q&A box. But again, if you are listening, if you have any questions that came up, please feel free to enter them into the Q&A box. It's a little bit easier for us to get to. All right, so I'm going to go ahead and get started with these. So Priyanka says, thank you both so much for sharing your insights as well as all your work on this important issue. The backsliding of women's rights and freedoms more broadly, beyond even just Roe, is really disturbing to her. So her question is, given that so many of these battles are conducted in the legal spheres, what are some of the most impactful ways non-legal people can support your efforts, again, besides voting, which we talked about a little bit? So how can we get more involved?
Well, I can start. I mean, this is always the question that it's a great question that people ask. It's sometimes harder to answer because yes, voting, I think the 2 things that always come to mind for me are talking about abortion. Both my grandmothers had illegal abortions before Roe that I did not know about until they had both passed away. And both my aunts have had abortions. Like everyone on this Zoom knows someone who has had an abortion, as Renee Bracey Sherman, who founded an organization of abortion storytellers called We Testify, always says everyone loves someone who has had an abortion. So it's not a stranger out there. If your family is formed in part by abortion, and so to talk about it, I think is a very, can be a big first step, but is the first step that's important. And the other is, in addition to voting, right, giving money to, in particular, abortion funds, which are organizations that exist in all 50 states, as well as the national network of abortion funds that help cover the cost of abortion care, but also all of the logistical challenges that have only gotten more challenging since Dobbs. I mean, Roe was never enough. Abortion has always been too hard to access in the United States, but right, getting time off work, paying for childcare, getting a bus ticket, staying over in a hotel or motel, all of that costs money in addition to the care itself. So abortion funds help try to bridge that gap for folks who are accessing abortion. So supporting abortion funds is another excellent thing to do.
Right. And if I can just add to that, I've long thought that disclosing one's abortion to someone, you don't have to shout it on the street, but you have to be attentive to the people, the women around you, your cousins, your younger sisters, your classmates, anyone, your coworkers, to see if a quiet discussion would be useful for someone who's having a time deciding or is stuck because they have no one, they think they have no one to talk to. And I agree completely. When you said everybody loves someone who's had an abortion, I lowered the threshold. Everybody cares about someone who's had an abortion, so you don't have to worry even, and would be very surprised. And if they thought that their child's second grade teacher ever had an abortion, or you can pick the random category of person. And what this does, I in the book I wrote, I have a chapter called Abortion Privacy, Abortion Secrecy. And the idea is no one should be forced to say they had an abortion or they're thinking about having an abortion, because it is a private matter. but there's a line between keeping something private and keeping something secret. And I want to suggest that when you keep something secret, that to me, that portends that you're afraid of something, and that the reason you're keeping your decision-making process secret is because you think harm will come to you if you divulge it. And so I think that this line of and people feel empowered if it's my business, it's my privacy issue, not anybody else's. True. But if you're actually scared out of your wits and think something bad is going to happen to you, like your parents will kick you out, your friends won't like you anymore, you'll be out of your church group, whatever it is, that's a different matter. And that requires some greater effort by those around a person to cure. So what we want to do is normalize abortion as a health decision. It's many kinds of decisions, but among other things, it is a medical decision. You have to have medical care is part of it. It's part of reproductive medical care. And that and what these statutes that we talked about earlier have been trying to do is pull abortion out of medicine, so that don't even talk to us about what's reproductive health care. Don't be ridiculous is the response. And but actually, and here's an example of how to pull it out. In many states, telemedicine is no longer applicable. Can't be used for abortion. Now, abortion is an extremely good example of a procedure that is treated very well by telemedicine. If you're in a rural area and you don't have a clinic you can go to, talking to a doctor on Zoom can be very helpful. And it is not to be prescribed the medication abortion, for example, the pills, does not require any physical contact between you and a medical medical professional. You might need an ultrasound, but that's usually done by a technician. So we don't have the involvement, and it's a perfect thing to be able to discuss on a Zoom if it were allowed. And that's another, abortion is tainted by being taken out of what every other kind of medical procedure gets as a manner of treatment. So it's like abortion can't get a fair shake anywhere, just in terms of being a procedure that requires medical care. So that goes to your point about, well, it goes to my point, I guess, about normalizing and making abortion like any other medical procedure.
Great, thank you. So I just want to read, Arthur Schwartz had noted before Roe v. Wade, really the ability to obtain an abortion was determined by socioeconomic position. So Hillary kind of goes to what you were saying. He notes that, it was kind of selective on who had access, and it was usually members of the family of physicians or faculty at universities and the wealthy who could travel to Europe. So just want to, reinforce kind of that from Arthur, but then also we had a comment from an attendee who was saying that there's a lot of newer medical students who are wanting to learn about abortion care, but in states where it has been banned, they no longer can learn that in medical school. And so I was just listening on NPR this morning that there are certain groups that are trying to fund those students being able to have to travel to other states to be able to learn this care. So not only does it affect the students and what schools they are applying to for medical school, but then also, again, has fewer even OBGYNs available in some of those states that are passing those laws. So I don't know if, Carol, you want to mention anything on that.
Well, Medical Students for Choice and a few other organizations are doing for medical school what Students for Reproductive Choice did for law schools, which is getting people involved. But it's so much more serious in the medical school. An abortion is basically the procedure is in an early abortion is very simple, and it is something that one would think doctors, especially family practitioners, should know for non-abortion purposes. someone might be having a miscarriage and require the same DNC that would be given if it were an abortion. And to think that doctors are going out into areas and are not trained in this is ridiculous. And that it's been so politicized that medical schools don't all offer it is unprofessional and dangerous. And of course, it's dangerous for women.
And Hillary, maybe you can answer. Gail has a question on how pregnancy is at risk for all women because there are certain laws now that are targeting physicians' practices. And so OBs are leaving some states, but maybe you can speak to one of those laws.
Yes, so I'll say maybe two things about that. So yes, I mean, sort of the ripple effect, it's too small. It's like a tidal wave of impact, I think is well beyond abortion, right? The fact that Dobbs affects abortion should be enough, but the ripple effects are huge. So we have seen, I think in particular, there have been stories out of Idaho that hospitals have shut down OB-GYN practices in a hospital because OBs are leaving the state because Idaho has essentially 3 bans that together prohibit essentially all abortion care. And the way that most of those bans work is they impose often criminal penalties on providers who violate them. And so the risk of providing care that is the best evidence-based care, they're met with potential for criminal penalties. And, miscarriage care, as Carol was talking about, and abortion care are the same, whether it's with a procedure or medication. That medically they involve the same skills and medications. Miscarriage care is legal. But sometimes it's not as clear, is this an abortion or is this a miscarriage? And physicians are rightly afraid of criminal penalties. And the other piece of that I'll mention is we have filed a case in Texas challenging their total criminal abortion ban on behalf of, it's now 14 women who experienced medical emergencies and were the proper care they should have gotten is abortion care, and their physicians wanted to provide that to them, but Texas has a very narrow medical emergency exception, and their physicians were forced to say, you're not sick enough for me to provide you an abortion, so we can wait until you are sick enough, come back to the hospital. And the named plaintiff in that case, Amanda Zarowski, is one of many horrific stories that we have heard of. Her water broke at 18 weeks, way too early in a wanted pregnancy. It was really hard for her to get pregnant. And her physician said, well, you're not, the proper care she should have gotten is an abortion. Her physician said, you're not sick enough for me to give you an abortion. And over the course of 3 days, she was told to go home. Eventually, she came back to the hospital. She had sepsis, which is this life-threatening infection. Ultimately, she was sick enough and they provided her an abortion, but the consequences may be that she may not be able to become pregnant again, given getting so sick that she was sort of in dire circumstances before she could even get abortion care. So again, just one small or one person story that we are hearing from every state that has banned abortion. And it's really scary because you want to be able to go see a provider and get normal care and not have your physician fearing 99 years in prison, which is what the penalties are under the Texas law.
This made me think of another example. I was and it goes back to the question that somebody else, well, what can we do if we're not a doctor and we're not a lawyer? And one thing that I think is called for is a kind of generosity, digging deep to find a willingness to understand that women may choose abortions for all kinds of reasons that you might be unaware of. And I was teaching a seminar once in another state, and it was a 1-week course. And a woman came up to me at the break of the the intermission, and said, I want 20, I want 20, she said, I want 20 minutes of your second half of your course, the second half of this class. And I said, well, what would you do if I gave you 20 minutes? She said, I want to talk to this whole audience. And she said, do I look like a monster to you? So I said, no, you look lovely. And she said, well, people think I'm a monster because I had a late term abortion, because we didn't know it, but the fetus was collapsing her blood pressure. I can't remember. I don't know the medical terms, what was happening. But she said, and she said, the doctor said, we're scheduling you. She collapsed on the street. And the doctor said, we're scheduling you for an abortion. And she wanted this baby very much and said, oh, no, we're not. I'm having a second opinion first. And when she got, and then she did have the abortion, but it was late term. And she felt so stigmatized. And I thought it was very interesting that what she wanted to do was say, I am one of the faces of a late term abortion. Think about that. That's all she wanted. I gave her the 20 minutes for sure. And it turned into a very interesting class, but that's being open to understanding what it feels like to have to be losing a baby or to have an unwanted pregnancy is a challenge, because if you're a man, for example, if you're someone who's never thought about these things, you need to call upon yourself to think, can all these women be crazy? Are they all wicked? No, but you have to learn why and think about it. So that would be another, just a kind of openness and generosity and imaginative dealing with people you don't know.
So we have a few questions on the Supreme Court. So I'm going to kind of start with a couple questions directed at specific justices. So Kathleen says, what do you both make of the lack of care for accurate facts / history in Alito's opinion, saying quickening doesn't happen at 15 weeks. Abortion was practiced with some openness in the 19th century. So she was shocked by the lack of effort to persuade and the failure to correct obvious errors after the draft opinion leaked. And then we had a couple other questions on kind of the Supreme Court, and even when presented with what you might consider logical or scientific evidence, continued with that. So kind of what do you make of Alito's opinion specifically?
Well, I think I talked a little bit about his astonishment that he might have to know some facts, and that empirical data is very difficult for judges. That's just insane. And so where this leads us is, should we have time limits on the Supreme Court appointments, for example? I mean, is our system, we're in a very strange position right now. And I think it's a great deal of thought is needed to figure out how to have the court behave in ways that we thought judges behaved. I'll just give one other example. It takes the question off a little bit, but I was very surprised when now Justice Kavanaugh and Gorsuch had their nomination hearings. And they were both asked, do you believe Roe is the law of the land? Which means it's the law. And they both said, yes, I do. Do you understand Roe to be the law of the land? And they both said, yes, I do. What they didn't say was, until I can do something about it. They gave an answer that was in some way in their heads true, but and what interested me was how people responded to them saying that, and then of course voting for against the right. And that goes, I think about this, did that go to their integrity? Did that go to the fact that nobody believes anything anybody says anymore? And we all know it's performative, to use Hillary's word. They're all play acting for each other and for us and the audience. So that's a very difficult question and it's a structural question about how how our judiciary is, the term limits and the 9. Hillary, were you going to add here?
I mean, I think it makes our jobs really hard, right? Like, we deal in facts and reality. And I mean, the other example of this, it's not just the Supreme Court, but the challenge by anti-abortion physicians to try to get mifepristone, the first medication used in a medication abortion and also used for miscarriage care, to get it off the market completely, right, is a step to a national abortion ban. But it is based on the idea that mifepristone is unstudied, is unsafe. Mifepristone has been approved by the FDA for more than 20 years. It has been studied and studied and studied so much. And yet a federal judge in Texas, in a case filed so that federal judge would be the one to get the case, ruled in favor of the anti-abortion physicians' total request to essentially remove mifepristone from the market. That has been now paused by the Supreme Court, but the litigation will continue. And it's just, in any other time, that case would have been laughed out of court because the legal arguments, the facts are just totally off the wall. But today they do sometimes find a receptive audience, or the litigants, literally choose their audience so that they get the outcome that they want.
Well, this is great. You're both answering questions that I haven't even gotten to ask yet. So we did have a question on kind of if there would be a better strategy given the difficulties and kind of the reasonable arguments being made. So I think that one I can clear. And then we had another question on the—
Excuse me,
Yes.
Can we just, I don't know if this is what that question was about, but one of the things that people have been saying since Dobbs was, okay, we just need a new approach to what the right is based in. And so many people have said equal protection, that this is really sex discrimination. And it was interesting that Alito stuck that in his opinion too. And he said, by the way, if any of you are thinking of coming back with an equal protection argument, don't. This has nothing to do with it. So, cutting it off at the pass. And it's not a very amenable court for that argument anyway, but this is a moment of kind of lawyers and being stuck with personnel, stuck with the new rules that are coming in, stuck with a new dismissal of precedent, stuck with, we're in a very, I don't know if it's a fluid moment, but things are really changing in law, how law operates. And it's extremely difficult.
Maybe Hillary, we had a question on what your take on the religious federal judge's decision on overruling FDA's approval of mifepristone and SCOTUS's potential ruling on weakening federal agencies' roles in interpreting congressional laws and making necessary expert decisions. So maybe you can just expand a little bit.
Yeah, so this is the case I was mentioning before, trying to get mifepristone off the market. And it's like surprising, not surprising, because again, this is sort of one strategy to advance a national abortion ban. If mifepristone is removed from the market, it really threatens the most commonly used regimen for medication abortion in the country, which over the last several years, access to medication abortion has been incredibly important. Medication abortion accounts for more than half of the abortions people have in the United States, partly for the reasons Carol was talking about. You can access it via telemedicine. Like you can access lots of other medications through the mail after a consult with a provider. And anti-abortion activists and physicians don't like that it's easier to access and that people have the ability to make the decision to get this very safe health service. It's always very hard to predict. I think it was an absolute relief that the U.S. Supreme Court stayed what the lower courts had done in completely removing mifepristone from the market or adding additional restrictions to it. But that stay is not forever. We are waiting right now for a decision from the Fifth Circuit on sort of a midpoint in that case that U.S. Supreme Court has sort of preemptively paused whatever the Fifth Circuit does. But these cases can go up to the Supreme Court really quickly, and that's what happened with Texas SBA. We've seen a lot of decisions on the shadow docket that disrupt the status quo, that really change people's rights and lives. So like would not get complacent about it at all, right? The Supreme Court did a very normal thing in keeping the status quo on access to mifepristone, but we don't know really what's around the corner. And I think, sorry, the question was getting at broader threats to deference to federal agencies, like independent agencies like the FDA, and like, yes, right, abortion litigation doesn't happen in a vacuum. It is about other areas of law too, right? Dobbs will affect rights to contraception, to same-sex intimacy, to same-sex marriage. So a decision about mifepristone is a pharmaceutical. It could have broader impacts on access to pharmaceuticals, which is why many drug companies filed an amicus brief saying, don't do this, right? The FDA has rules that it follows and that it followed with mifepristone. Don't mess with that here because we're concerned about what it can do in other contexts, right? Sometimes it applies equally to other things, and sometimes abortion gets a special bad rule. So we'll see.
So we had a question from Lou Mendelson saying, given the current conservative Supreme Court, what are the practical and legal options for increasing access to abortion? But I want to add, we had another question about creative maneuvers, like maybe expanding the court. So I don't know if you can speak to maybe any either practical, legal, or creative options.
Mhm.
You want to start or you want to start?
Oh, you know, nobody wants to be called a court packer, but these seem to me to be very strange times. And I was reading an article about there are 13 circuits. So let's have 13 judges. That seemed to me quite fair. And like our Supreme Court has a very light compared to other Supreme Courts, not national Supreme Courts docket. I mean, they choose their own, they choose what they want to hear, when they want to hear it and all that. And so I don't think it would be too burdensome. But one thing is that remember, the appointment of judges is not only at the level of the Supreme Court, it's all the way down, which is why Julie's appointment was important and good. But there are a lot of judges now at federal trial judges, and they hear cases, and they're the ones who will be moving up. So keeping an eye on who's getting appointed in your state and is very important. And I guess you'd go to the Bar Association for that if the Bar Association is amenable. You know, it's a big job, and everybody's got to pitch in and do something. I don't have any other creative things, and I can't figure out. You know, the very brilliant of Trump to appoint young judges, because with a lifetime term, maybe a lifetime term isn't necessary anymore. Maybe, but if we are bold enough to try to, I mean, it's a matter of Congress. And so that how's that going? How much are they gonna handle? So we're in have a very limited area to work in right now.
Yeah, I'll just add a lot of what we're talking about, right, has been federal court, and there's a whole other 50 state court systems where, I mean, Center or others have been litigating in the state courts since we were founded 30 years ago, but we are returning, right, with more force to the state courts. This is going to be a long sort of not restoring row, but trying to build something better. And there are 50 state constitutions, some of which have different protections than the US Constitution that we can leverage, right? The Kansas Supreme Court recognized a right to abortion in 2019, the Montana Supreme Court in 1999, and just reaffirmed it unanimously a few weeks ago. The South Carolina Supreme Court this year held the South Carolina Constitution guarantees a right to abortion. The flip side of that is it's a patchwork, because the same day South Carolina made that decision, the Idaho Supreme Court found the exact opposite. So it's a long incremental, I try to avoid the word fight, but essentially a long incremental strategy, right, forward. But we can't not do it, right? The alternative is sort of giving up, and that, I mean, at least to me, is not an available option.
I wanted to just add, and this is going back to an earlier question. I'm not sure which organization has the best map of this, but when you see what it takes to access an abortion, so if you were in Texas and Texas puts on a 6-week ban, okay, so big deal. You go to Oklahoma. Well, then suddenly Oklahoma has a ban. Then there are a couple of maps that radiate out, and you see how far someone has to travel from where they live to a state where abortion is legal, and it's huge. And that's so there was a question about someone had asked earlier about the cost of doing this, and if you're wealthy, you can go to Europe, or the U.S. people on the West Coast used to go to Japan, and on the East Coast to Europe, and now the abortion medication abortion seems to have stopped the practices of, we hope, of illegal abortions by non-providers, by people who don't know what they're doing, and the kind of injuries that women used to get with coat hangers and so on in the prior to Roe. But we're still in a situation of people having to travel to exercise a right they don't have in their own state, and the distances are not trivial. And so contributing, as Hillary said earlier, to funds that help women get to where they need to go is really crucial. It's very practical. So yeah.
Well, we had a question on why giving states the right to decide on pregnancy is flawed. And I think that kind of patchwork of each state doing their own thing, and then people having to keep track of every state's decision, can complicate that matter for people.
Yeah, and just because the center has a map, so an app, we used to call it What If Roe Fell, now it's called After Roe Fell, and shows sort of what the level of protection under state law for abortion there is in each state. And you can see, right, there are regions of the country where abortion is banned. So if you are in Mississippi, you are surrounded on all sides by states that have also banned abortion, just for one example.
Okay, so we have just 5 minutes left, so I kind of wanted to turn it back to each of you for any closing thoughts, but we also like to ask if there is any other resources that you can suggest for people who are interested to continue following this, either journalists, books, podcasts, whatever it might be, so that they can keep learning on this topic, staying up to date. And then any closing thoughts, and maybe we can start with Hillary and then close with Carol.
Yeah, I mean, I think the main resource I would recommend is that After Roe Fell map. I think it has been a resource the center has invested in for many years before Dobbs, and has evolved and been really helpful in showing visually what access or what legal protections at least look like. And as to closing thoughts, I remember being a student of Carol's when she was working on her book about abortion, and absolutely never did I think I would be litigating abortion cases, let alone this really devastating case in Dobbs. So I think that somewhat helps me think about, you don't really know what's around the corner. It could be terrible in a way like this, or it could be better. And I feel a real responsibility to work to make it better and not, as I was saying before, not just restore Roe, which really were critical but moderate protections for abortion. Even before Dobbs, we were trying to make access to abortion much more what it should be. You know, there shouldn't be those trap laws. Accessing abortion should be walking down the street to the pharmacy, right? It should be as easy as any other health, as many other forms of healthcare, especially given how safe it is and how important it is to people's lives. And it will be a long, many-year fight to rebuild that and to rebuild something better. That's, again, not just about abortion, but access to pregnancy care, right? This country has horrific maternal and infant mortality rates and mortality and morbidity rates in particular for Black women. And those are the people, right, who are most harmed also by abortion bans. So a lot of the things we've talked about tonight, voting restrictions, abortion rights restrictions, and access to pregnancy care in general impacts the same communities and did before Roe and will continue in this post-Dobbs era. And acknowledging that is sort of the foundation for trying to rebuild back something better. I'll leave it at that.
Well, I wanted to say that there was one group we didn't talk about tonight, which are teenagers. And that's and I think about them a lot because they're in a very bad situation. And prior to Dobbs, states had quite a few states had a procedure by which teenagers could go to court to get permission to have an abortion without talking to their parents. Most of those are wiped out. But I think if you take a select group like minors, I mean, they have a lot of problems about accessing care anyway. And now that some don't have drivers, I mean, the technical parts of getting to an abortion provider are difficult, and it would be worth if in a person's state they found one agency or NGO that worked on the issue and contributed to them with time or with money. That's all you can do is take a piece of it and try to make that piece better. And I think that that's a way of thinking about it. If you're doing Supreme Court work like Hillary, that's thrilling and big and counts for everything, but it doesn't account for everything, which is that there are individual cases that need special, that need as much attention as they can be given. So I guess that's where I'd stop. It's a very unhappy moment, a very unhappy time right now. Nobody in the reproductive field, everyone's working very hard on reproductive justice and reproductive everything, but one is aware that every time you think of a solution for something, or there's a way you can improve things slightly, you often get whacked down. And just one example is referendum and initiatives. So they're dodgy on their own. I mean, because anybody who gets a certain number of signatures, but for personhood amendments and such, they've been very useful. And what's happening now? States are saying, well, however many signatures you used to need to get something on the ballot, now you need, I don't know how much it is, half again as many. So the idea is, oh yeah, we're for direct democracy, except some of those people are voting for things we're not so keen on. So we're going to make it harder to do that. And that's the sort of slap down, that is very hard to keep working with. And then you just keep working.
Well, thank you both so much for being with all of us tonight. There were just so many questions. We weren't even able to get to all of them. But we are getting already some notes saying thank you so much for the discussion. So again, thank you for sharing your wisdom, all the history that you were able to share with us. And we did record this event, and I will be sharing the link probably tomorrow. So thank you both again, and everyone have a great night.
Thank you so much.